Presenting on behalf of the measure, 2 minutes each, 2 witnesses in opposition, and then we will bring the public up after the support position, those in support to please state their name, affiliation, and their position, and then we will do that with the opposition, and hopefully we can move things along. We still do have about 15 matters, about 10 matters now that we've gotten the consent calendar done and the items that have been pulled. So let's see how efficiently we can move forward. And with that, Senator Monning, file item 1. Good afternoon, sir.
Thank you, Madam Chair and members, and thank you for the consideration for the pro tem and order of presentation this afternoon. It's indeed my honor to present SJR 13 on behalf of President Pro Tem de Leon. I'm deeply concerned by the inexplicable decision of the United States Supreme Court to hear a challenge brought by plaintiffs in Texas to the long-standing democratic principle of one person, one vote. Since it was first affirmed 51 years ago by Chief Justice Earl Warren's Supreme Court, one person, one vote has been a widely articulated and consistently upheld tenet of our nation's Constitution. Before that time, political districts across the nation were arbitrary and imbalanced, and millions were underrepresented. Los Angeles County and its 6 million people, for example, had the equivalent voting power in our state Senate as a rural district with barely 14,000 people. This challenge now is nothing more than a cynical and transparent effort to turn back the clock on decades of legal precedent and return an unjust, unequal system of redistricting that could greatly disadvantage diverse and urban communities and deprive millions of American residents, many of whom are either Latino or Asian, of political representation. In California, overturning the one person, one vote could lead to a system of political segregation that only counts 3/5 of our population and essentially would ignore the rest. This resolution makes it clear to the Supreme Court of the United States that Californians believe that all people, not just adults who can register to vote, deserve equal protection under our laws and fundamental political representation. Members, I respectfully ask for your aye vote on behalf of Senator De Leon.
Thank you, Senator Monning.
Witnesses in support.
And if you'd go ahead, our witnesses in support.
Thank you, Madam Chair and members. Kevin Baker for the American Civil Liberties Union of California in support. I can't add very much to what Senator Monning has already eloquently described. The United States Supreme Court had held long ago, and it's repeatedly reaffirmed since then, that the Constitution requires congressional districts to be equal on the basis of total population. Until this case, no one had ever suggested that the rule would be any different for state legislative districts. In fact, the district court threw out the challenge in this case for failure to state a claim, which, as you know, Madam Chair, means that the case is essentially totally lacking in merit. We believe that the legislature is right to be concerned that the Supreme Court has reached out and chosen to grant review in this case. It would be a very odd result indeed, we believe, if the constitutional right to equal protection of the laws were suddenly demeaned that everyone is not to be counted equal. And other than that, I would simply commend the members' attention to the very fine analysis produced by the committee staff. Thank you.
Thank you very much. Next witness, please.
Good afternoon, Madam Chair and the members of the committee. My name is Deanna Kitamura, and I'm with Asian Americans Advancing Justice Los Angeles. We are the largest civil rights organization in the nation focused on issues affecting the Asian American and Pacific Islander communities. And I am a voting rights attorney, and I am here to express my organization's strong support for SJR 13. We've worked on redistricting since the 1990s, including this last round based on the 2010 census, so we understand the importance of fair and adequate representation when drawing district lines. As a civil rights organization, we strongly believe in the Equal Protection Clause's fundamental principle of one person, one vote, and are deeply concerned with the U.S. Supreme Court's decision to hear the Evanwell case. The filing of the lawsuit is about partisan politics and not about what's in the best interest of our democratic society. It's important that elected officials represent and address the needs of all residents, including children and non-citizens. Creating a system that allows representatives to discount the needs of some individuals is anathema to our democracy. A negative ruling would hit Asian American communities in California particularly hard, and that's because in California, 20% of Asian Americans are not yet U.S. citizens. That's nearly 1.2 million children and adults. There are also over 1.1 million U.S. citizen children in California who are of Asian descent. That means a negative decision in Evanwell would discount over 2.3 million Asian residents in California. Because all persons should be protected by the Equal Protection Clause, we strongly urge you to vote yes for SJR 13. Thank you.
Thank you. Other witnesses in support, please, just your name and affiliation.
Good afternoon, Madam Chair, members. Santosh Siram Santana, representing the California Asian and Pacific Islander Budget Partnership, in strong support. Thank you.
Thank you.
Good afternoon, Chair and members. Jeanette Sanipatin, Legislative Attorney for the Mexican American Legal Defense and Educational Fund, also in strong support.
Thank you.
John Lovell on behalf of the California College and University Police Chiefs Association, in strong support.
Thank you, sir.
Esperanza Ross on behalf of the United Farm Workers in support.
Thank you.
Kimberly Rosenberger on behalf of Service Employees International Union in strong support.
Thank you. Other witnesses in support? Are there any witnesses in opposition to this? All right, we'll open it up. I just have a statement that I want to make. I find this, the court's behavior in this to be absolutely inexplicable to me. Absolutely inexplicable. I mean, when this country first started, the only people who could vote were landed gentry white males. And I thought we had come a long way. The women had to fight for the vote. African Americans had to fight for the vote, and here we are. The practical application, should this pass, would be to deny far too many people the fundamental right of a democratic society. And I would love to hear what the argument is to go back 200 years in our nation's history, which was a time, frankly, which, as we look at it today, was a sort of an embarrassment. That you were you had to be a privileged white man owning land. Everyone else was in Protestant white men, says Senator Hertzberg, yes. And so it is shocking to me that this is where we are 200 plus years later. And so I very rarely sign on as a co-author in a bill that comes before this committee, but this is so fundamental to the core of everything that a democracy is supposed to be. And I appreciate the senator bringing this. I know it's just a resolution, but I think it is incumbent upon this entire state, and I don't understand the partisan, that this could be a partisan issue. This is an issue about democracy, first, foremost, and fundamentally. And so I know I don't have very strong feelings about it, but I just really wanted to be very clear. And I would invite anyone to explain why we should be going back to a point where many of us sitting in this dais today, frankly, might not be able to vote. So with that, are there any other comments by the members? Senator Leno.
Thank you, Madam Chair. Clearly to endorse your statement and as a proud co-author of the resolution for all the reasons that have already been described. And it would seem this is yet another attempt to change the rules of the game out of concern that they can't play by existing rules. And I certainly understand the assault on the fact of and the respect for our ethnic communities that could be, and immigrant communities that would be excluded. But from the mindset of the proponents of this change, how do they make a case that children should be excluded, citizen, non-citizen children should be excluded, and that the number of children in our districts should not matter and should not be counted? How do they account for that?
I don't have an answer to your question other than to underscore the potential impact. There are so many different measurements today that are based on census count and based on political representation, based on census that has never been taken based on, are you a property owner, are you a registered voter, are you eligible to vote. Census includes children, it includes immigrants, it includes workers who may not have the vote but who are paying taxes, who pay taxes whether they're renting or whether they own property. Taxes are withheld from every paycheck. And so the very fundamental notion of equal protection, in which under our federal constitution and our state constitution, a non-citizen is afforded due process of law. A non-citizen is afforded the right to defense in a criminal proceeding. All of the body of rights that extend based on, not on citizenship, but based on residency, are potentially at risk should the Supreme Court follow what some seek from the state of Texas. So I'll just make this my close, Madam Chair. I think this goes far beyond voting rights. It goes to fundamental protections of our federal and state constitution to residents of our state and to residents of our nation. And the very formulas used to determine federal reimbursements to the states are often based on accurate census data and based on apportionment, often of voting districts. So again, we would be shooting ourselves in the foot to wish this upon ourselves for any reason, because it would result in the curtailment of federal project funding for different programs potentially that are currently supporting children, citizen children. This isn't just an attack on non-citizens. This is an attack on all citizens. And with that, Madam Chair, I'll close and urge an aye vote from my colleagues. Thank you.
Thank you. Unless there are any other comments? None? All right, the chair will entertain a motion.
So moved.
Moved by Senator Leno. And the motion is that the resolution be adopted and sent to the Senate floor. Please call the roll.
Jackson?
Aye.
Jackson, aye. Morlock? Morlock, aye. Anderson? Hertzberg? Hertzberg, aye. Leno? Leno, aye. Monning? Monning, aye. Wachowski? Wachowski, aye. 6-0.
Yeah.
6-0. We'll leave that measure on call. Thank you, folks, for coming and speaking up on that fundamental constitutional issue. Our next item is file item 3, Assemblymember Holden, AB 265. Assemblymember, welcome.
Thank you.
Good afternoon.
Good afternoon, Madam Chair and members, senators. I'm presenting Assembly Bill 265 to expand upon 2012 legislation regulating buy here, pay here car dealerships. As a bit of background, buy here, pay here auto dealers are those who keep over 90% of their auto loans in-house, opposed to traditional dealerships who sell the majority of their loans within days. Keeping the loans allow buy here, pay here to avoid most lending guidelines, opening up vehicle sales to people with poor credit. To ensure payments, dealerships began installing starter interrupt devices on cars, allowing a dealership to remotely disable a vehicle if a payment was not made. In the intervening 3 years, it is now clear that 48 hours simply is not sufficient notice for auto buyers, many working 2 or more jobs, to understand why a payment is late and work to find the payments to keep themselves in their cars. It is also clear existing penalties have not deterred bad actors. Assembly Bill 265 addresses these problems in 2 ways. First, AB 265 provides buyers additional notice before a car is disabled. This gives buyers time to rectify any clerical errors, to find the money to make their auto payments. Secondly, AB 265 clarifies existing law and makes each violation punishable. Additionally, AB 265 doubles current penalties on bad actors. Assembly Bill 265 now reflects an agreement between consumer groups, industry, local governments, and law enforcement. This bill will help thousands of working-class Californians, and I respectfully ask for your aye vote.
Thank you very much. Witnesses in support.
Madam Chair, members, my name is Aaron Lewis with the Consumer Federation in California, here in strong support of the bill. Just briefly, the notice that will be, the additional layer of notice that will be afforded by this bill will allow buyers to plan ahead and have sufficient time to work to resolve account disputes or errors. And additionally, it'll ensure that their vehicles are not shut down in opportune or dangerous times, such as during a road trip or while caring for a sick loved one, or when a vehicle is parked in an area that might subject it to towing or additional tickets and thereby compounding financial distress. So just briefly, and urge your strong support. Thank you.
Thank you very much. Other witnesses in support.
Madam Chair, committee members, my name is Pat Zenzala with KP Public Affairs. I'm here on behalf of the Payment Assurance Technology Association, and we're in support of the bill and want to thank the author, staff, and the Consumer Federation for working with us.
Thank you very much. Other witnesses in support, briefly.
Good afternoon, Madam Chair, members. Sabina Takar with the Consumer Attorneys of California in support.
Thank you. Other witnesses in support.
Good afternoon, Chair and members. Bless Shepard, representing the Silicon Valley Community Foundation. I want to thank the author. We're in support of the bill. Thank you.
Thank you.
Ed Behrens on behalf of the Los Angeles County Board of Supervisors in support.
Thank you, sir. Any witnesses, any other witnesses in support? Any witnesses in opposition? All right. I just have a couple questions. These, as I understand it, these dealers not only sell the vehicles, but they also do the financing. So my question is, why are these dealers not regulated under our lending laws? And wouldn't that solve many of the problems that we've seen with these dealers who repeatedly sell, finance, and then repossess the same car? In fact, isn't it that they make their money hoping that they get to do this over and over again, and thus they don't have to make any decisions about the creditworthiness of the individuals who are buying the cars? Frankly, it seems like with the hope that they will default. So do you have any insights that you can share with us on that?
None other than I agree with you. And I think in 2012.
Well, that's a good start. But
no, all I could say is that including Senator Wachowski in 2012 had a bill. Senator Liu at the time had a bill that was addressing the issue as you described, that they would be treated under lending statutes and rules, and the governor vetoed the bill. So we're trying to recognize that the time frame is limited. We're trying to operate, even though we agree that maybe the boundary should be expanded. This bill does not do that. It works within the existing law, and it allows for the time frame to be adjusted so that families who, I mean, maybe it's not even a payment issue as much as it is a technical error, and that they're penalized and there's not enough time to correct the error, and that's the reason why we believe the importance of this bill in its narrow focus is important to move forward.
Well, do you happen to know whether there is any kind of creditworthiness assessment that is done by these dealers?
I'm sure they go through some type of review, but it's clear that they're not as concerned. Their standards may not be necessarily as high, and they probably even do it recognizing in some cases the ones that are really bad actors are probably hoping that that some will fall through the cracks and they have the ability to electronically shut down the car and repossess it, and not really give them an opportunity to.
Well, that seems to be part of at least the business model of some of these enterprises. Well, I appreciate your doing this. Obviously, I feel that we aren't, this is just sort of putting a Band-Aid on a procedure and a business that does tend to prey on those who are least fortunate among us. But thank you, and I appreciate the effort. Any other comments or questions? Motion by Senator Leno. Now, this was, I believe there were some amendments. Are you going to be taking the amendments as authors' amendments?
Yes.
As amended.
As amended? All right, very good. You may close.
Well, I respectfully ask for your aye vote and appreciate your consideration.
Thank you. All right, Madam Secretary, please call the roll.
The motion is due pass as amended to Senate Appropriations Committee. Jackson?
Aye.
Jackson, aye. Morlock? Morlock, aye. Anderson? Hertzberg? Hertzberg, aye. Leno?
Aye.
Leno, aye. Monning? Wykowski? It's 4-0 on call, ma'am.
4-0. We'll leave that on call. Thank you, Assemblymember. Next item up is Assemblymember Melendez, file item 4, which is AB 289. Good afternoon.
Good afternoon, Madam Chair and members of the committee. The California Whistleblower Protection Act provides protection to state employees in the executive and judicial branches who disclose improper governmental activity. Unfortunately, employees of the legislature are not covered under this act, nor do they have a protected process for reporting questionable government behavior. Given their proximity to members of the legislature, legislative employees do have a unique opportunity to help provide accountability by reporting any suspicious or unethical behavior. AB 289 would extend the same protection to other state workers, extend the same protection other state workers receive by establishing the Legislative Employee Whistleblower Protection Act. That's a mouthful, isn't it?
And you said it well.
Thank you. This act would prohibit retaliation against legislative employees who make protected disclosures of ethics violations. I'm here to speak on behalf of this bill is Phil Ung, who is the Director of Public Affairs for California Forward. Thank you so much, and I ask for your aye vote.
Thank you. Good afternoon, sir.
Good afternoon, Madam Chair, members of the committee. Philip Ung on behalf of California Forward. Our bipartisan board was proud to support this bill this year as well as last year. This bill isn't about what this bill is about is about the staff that work on this committee, the staff that work on your bills day in and day out, week after week, the staff that helped craft the budget that is now being announced by the governor and the leadership. And it's really about protecting the staff in a way that we think they deserve because of the service that they provide to the Californians. And so we ask that you support this bill because it seems silly to leave out the honorable staff that work in these four walls or in this building while the rest of the state employees have this protection. So we hope that you will give support in this committee as well as appropriations for those of you who were on appropriations where it actually died last year. So thank you.
Thank you very much. That's a twofer you just threw in there. Okay. Any other witnesses in support? Are there any witnesses in opposition? Any questions from the membership? Senator Hertzberg.
Direct your attention to page 4 of the measure. It looks like it was an amendment, recent amendment taken, I guess, Assembly amended in the Assembly on May 11th that says, line item 12 and 11 and 12, for purpose of this section, legislative employees includes a former employee of the legislature. Does that mean that somebody who works as a lobbyist who might be angry that you're not supporting a bill all of a sudden comes up with retaliation? Does former member mean somebody who served here in 1974? What does former member mean? Former employee, excuse me.
1 minute, Mr.
That's okay.
That's
all right.
So apparently that was added in the Appropriations Committee. It does cover former staffers. If that staffer does happen to be a lobbyist now, then yes, I guess that would cover him or.
Yeah. What about a former staffer that went to work for a department? And the department had a motivation. Ultimately, that's evidentiary in a time of a hearing. But the truth of the matter is, in whistleblower contexts, it's not. These are the kinds of things in the world of politics is that we balance out the framework here, where on the one hand, we want to make sure that everybody applies to the same rules. We want to make sure the highest ethical standards are here. But it's high stakes bingo. There's a lot of folks that got a lot going on here. And so often people are employees that are leaving and all of a sudden will then file a complaint to increase their leverage or whatever else the case may be. I'm not suggesting the notion is good, but it seems to me that broadly saying a former employee without limitations, without qualifications, at some level, in order to make sure, because the people in this building are subject to so much pressure on measures. And so what I don't want to have is the unintended consequences of having a chilling effect on honorable legislators doing the right thing and often taking on big interests. And it's easy to just, break them down by saying, we're going to go after them personally. They're going to face a jail fine. They're going to face a $10,000 fine because they're trying to do the right thing. And to me, leaving that wide open creates some challenges. I just thought of it now, would have given you heads up on it before, so I apologize for that, but it certainly bears some consideration.
Well, thank you, Senator Hertzberg. I appreciate your comments. I understand where you're coming from. However, just because it would cover a former legislator who you suggest may have a grudge, may have some axe to grind, doesn't mean that their accusation would be taken as the gospel. There does have to be some proof that is provided. You can't just hurl an accusation and expect that it will stick. I will also say that this applies and should apply to legislative staffers as well as the staffers for other branches of government, because they do have such a close proximity to everyone. Just because you work for a legislator and you may or may not have a grudge or an axe to grind does not mean that you don't deserve the same protection as everyone else in this building. We have very clear evidence that sometimes things take place in this building that shouldn't. You are very well aware of that, given the fact that you've served in the Assembly before, correct? So you know probably better than most people what can happen in this building. My goal is to make sure that if something is going on, that these staff members are able to report it and know that there are consequences for reporting something that is not true.
I think that, and I share your concern, but the way the bill reads, as I understand it, is that if you reveal a protected disclosure, or this protects against retribution, if you will, for a protected disclosure that is made to an enumerated body. It has to be made to either, if you are or were in the Assembly side, to the Assembly rules staff. If you are on the Senate side, it has to be made to the Senate rules staff. This is not just going out there and creating some kind of allegation to the public at large. This is a mechanism that requires, if you have a protected, if you are making a protected disclosure about some behavior that you believe was inappropriate, it has to be made to the relevant rules committee in which you were employed, or by which you were employed. So if you were, for example, now a lobbyist and you want to make some what is otherwise a protected allegation, it has to be made through the Assembly rules if you were working for the Assembly. And the hope and expectation is that they will do their due diligence and investigate before this is something that becomes of public knowledge, so to protect against, allegations that are false or otherwise misleading. So I agree that throwing that in sort of is a bit of a curveball if they are a former employee, but I think that the protection that does exist, because it has to be done to a particularly enumerated body, protects that. But again, there's an argument to be made, I think, and that's part of the concern, frankly. I think there's part of the reason that not only, can you argue, well, self-interest, the legislature doesn't want to hold itself up to the same standards as others, but as Senator Hertzberg points out, there can be some very high-stakes activity going on where people are willing to leverage whatever and however and whenever they can. But I think that this does try to create that mechanism that will protect against that happening.
I should address that in one further context, Madam Chair, and that is it possible that we could limit it on time frame? Because if in fact somebody observed an act, right? I mean, think about this, right? What's the purpose of what we're trying to do? We want to make sure these people have rights, and we want to make sure that the highest ethical standards are maintained and the rules that apply outside apply to us. But what about a limitation on time frame? If you're leaving here, because see, I don't believe that. I don't believe, like I have a little familiar with that stuff, and I think that what's happened now in society, that anytime somebody gets a hot potato, that they then feel compelled to do something with it. I don't think these are like days gone by where a committee, like Rules Committee or in either house, sits back and analyzes this and said, sorry, we're not going to do it. Everything's acted upon. And so if you have a situation where somebody's been gone, say, statute of limitations have run, whatever it might be, this is an open-ended deal where if you got something that you learned it while you're here, right? You learned it as an employee. Now it's 4 years later and you're going to decide to use that. At some point, there's a marriage between the ethical obligation to talk about it, right? And that just, it kind of concerns me because that's what just caught my attention. It's just such an open-ended deal. Put a reasonable time frame. We have statute of limitations. Jurisprudentially, the law has throughout everywhere except for murder the ability to have a statute of limitations on something. Shouldn't that be fair? That's consistent jurisprudentially with what we do in our society.
Would you be willing to consider putting a statute of limitations on it?
Well,
With murder and whistleblowing, that's right.
Except, you're right, everything but murder has a statute of limitations.
Last year's bill did have a limitation in it. This year's bill does not. So I am willing to consider factoring that in, something that we, 10 years?
No, it was actually less than a year.
Oh, no.
I believe. We'll look at the language, Senator Hertzberg, but we did consider that last year, and we did put a limitation on when somebody would be no longer considered a former employee and would allow to exercise this rule. Of course, the original version of this bill didn't include former employees at all. That was put in by appropriation staff who insisted that it go in. And so it wasn't something that was generated by either us, the sponsor, or the author's office, but by committee staff.
But I would agree that when it's fresh in your mind, I mean, there's a reason for statutes of limitation, and there's a reason that if we make it you don't want 10 years or 5 years. I mean, it's something that's fresh in your mind. And this should probably apply to all allegations, that there should be a statute of limitations. You don't work for someone for 8 years and then say, 7.5 years ago, there was, I mean, let's try to keep this an open and honest discussion where if someone is blowing the whistle appropriately, that they do so and that they're encouraged to do so, but they do so within a reasonable time frame. So, yes, Senator Leno.
Thank you, Madam Chair, and I'm glad the Assemblywoman is open to this, and also good to learn the history of your previous efforts with regard to statute of limitations. It's not just that an accusation may be made, but it has to be corroborated, and otherwise it doesn't go somewhere. There's also the real risk of damage to reputations. And so there is risk involved if we do leave this very open-ended. So I'd encourage it. And this is going to appropriations again? Yes. So, Madam Chair, I would just suggest that having expressed our interest in seeing that, and I don't think it should be any broader than what was in the earlier effort, that would be the expectation in appropriations, and certainly the chair at any time has the authority to bring the bill back if she had further concerns, but we would all support you in amending it in that fashion in accordance with the previous effort.
And I agree with your concerns. We don't want this to be an open-ended witch hunt where someone wants, to get back at Senator Leno or Senator Hertzberg and damage the good reputation that you've taken years to build. We don't want that. So that makes sense to me. So I am perfectly willing to talk about that and figure out, okay, what makes, the most sense as far as the statute of limitations. But thank you, gentlemen, for your input. I appreciate that.
So do we have a commitment that you will consider and put a statute of limitations in, and perhaps even we're trying to find out what exactly it said last year. Again, making it reasonable in the context, nobody wants a witch hunt. There are concerns. It should be appropriate. It should give people the freedom if they feel that they should be expressing their concerns about inappropriate behavior, but do it in a time frame that is reasonable. So.
And again, I'm willing to do that. You're right, there is a statute of limitation for most things in life. In this house, and in my house on the other side of the hall, though, we have had situations where statute of limitations have been increased, and not for whistleblower protection, but it seems the majority has decided that allowing people to come forward years later for other types of activity is okay. So
well, this
I wanted to point that out, that
I understand, but
what I don't want is...
This is particularly to deal with this issue that's before us. We're not talking, we're not talking about other issues where maybe it's appropriate to expand a statute. We're just looking for a reasonable statute of limitations to protect both sides in this kind of a situation. And apparently last year, the statute of limitations was created that was defined as a statute of limitations within 1 year of the most recent improper act complained about. And I think a year statute makes sense. Would you be willing to amend at the appropriations, at the point of appropriations, to include that?
Yes.
Okay.
I mean, it's what it was last year. So.
Right. But we're just asking.
You know, and my point was just that what we don't want is to give the appearance that we are protecting ourselves more than we are protecting everyone else in the public. So please don't misinterpret my point that I was trying to make in bringing up another issue. But you understand what I'm saying. We don't want to give that impression. So
we actually, what we could do is we could amend it here and then move do pass as amended in committee. Can we do that? Again, we're just asking you to put in what was there last year. It seemed appropriate. A year for this kind of allegation seems like a reasonable amount of time. So
I can't remember what I did last week, so a year. So.
I'm totally with you on that. So that will be an amendment, an author's amendment. Senator Hertzberg.
I just want to, for the record, indicate that some years ago, from 2009 to 2012, I served as co-chair of, I guess, the sponsors of this measure, California Forward. So whatever that's worth, I just want to put that in the record. This was, I might. But it's kind of chicken to ask an amendment be taken and then recluse yourself. So I don't think there's any conflict. We never addressed this issue when I was there.
And I thank California Forward. This is an important issue. This is, and you survived Senator Hertzberg. So, I mean, congratulations to you. So, so we'll put that in as a statute of limitation of a year, as articulated, as I've just read, and make that an author's amendment at this time. Are there any other questions or concerns? All right, seeing and hearing none. Motion by Senator Leno, if you would like to close.
I just respectfully ask for your aye vote.
Very good, and thank you for bringing this bill forward. Madam Secretary, the motion is due pass as amended to Senate Appropriations. Please call the roll.
Jackson?
Aye.
Jackson, aye. Morlock? Morlock, aye. Anderson? Hertzberg? Aye. Hertzberg, aye. Leno? Leno, aye. Monning? Monning, aye. Wachowski? Wachowski, aye. 6-0.
6-0. We'll keep that measure on call. Thank you.